The broadcast is now starting. All attendees are in listen-only mode.
Hello, good morning and good afternoon, everyone. Thank you so much for taking the time to tune in to our webinar today, Measuring USPTO Prosecution Outcomes, where I'm going to be talking about ways you can know whether U.S. Patent Counsel is doing a good job or not. So I'm Megan McLaughlin. I'm the product director for PatentAdvisor, which is just a suite of USPTO analytics solutions. Before this, I worked as a patent attorney at a law firm in Boston. So I have actually been out there practicing for a little while. And then I came over to the other side. And now I collect and review data about the U.S. Patent Office and the people who file there and the people who practice there. All right, so like I said, I'm the product director for this USPTO analytics tool called PatentAdvisor. And one of the major goals of that product is to increase transparency between U.S. attorneys and the clients that they're working for through data. So in the last webinar in this series, we focused on benchmarking corporations. How is one filer at the USPTO doing versus another? Is Samsung getting better results than LG? But in this webinar today, we're going to be focusing on benchmarking law firms. So is one U.S. counsel doing better than the other, and how? So my goal for today is to add value to your U.S. patent practice. So if you're a corporation, I'm hoping I can help provide you some insight into your U.S. counsel and what they're doing. And if you're actually practicing as U.S. patent attorney, I'm hoping to give you some tools for communicating with your clients and for proving them your worth objectively. So I've been in the U.S. patent industry now, unbelievably, for almost a decade. And in that time, I've seen some pretty significant changes. And I'm sure everybody thinks this, right? Everybody thinks that, oh, in the time they've been practicing, that they've seen the most changes. And I'm sure that if you practiced 10 years before I did, there were also some significant changes in the industry. But I've been in the industry, in the 10 years that I've been with this industry, from both sides, from actually practicing as a patent attorney and from reviewing the data about those who do practice. One of the big changes that I've seen is how attorneys and clients relate to each other. So specifically, what I'm seeing is the industry changing from a relationship-based system to a data-informed system. And I say data-informed intentionally instead of data-based, because there's obviously still a big relationship component there. But objective metrics, like the type we provide at LexisNexis, are starting to play a larger role. In my first year as a young associate, I actually attended a training on how to get new clients. My firm was very forward-thinking in that. I think most firms just wait until associates are partners to try and bother to train them on how to bring in clients. But my firm got us a lot of training really early on. And the presenter that had interviewed hundreds of different corporations, asking them why they hired the lawyers that they did. And then he generated a wordgram based on their responses. I don't know if you guys remember wordgrams. They were huge on social media about 10 years ago. And basically, they just show which words are prominent in the interviews. And right in the center of that wordgram, way bigger than any of the other words, was the word relationship. It was all about forming relationships with your clients. And that makes sense, right? Because there was no other option at the time. It's like today when you have to go and pick a doctor. There's no database you can go to, a website you can go to that says this doctor gets the best results, and probably nor should there be. But there definitely wasn't anything like that for patent attorneys back then. Well, fast forward to today, I work with a lot of corporations that file at the USPTO, and I don't think there is a single one that I've worked with that files any significant number of patents at the USPTO who isn't trying in some way to keep some kind of report card on its outside counsel. And one of the top reasons today that law firms contact us is because their clients have asked them for a report card on their performance. And they just don't have that info, and they have to get it from us. So I'm really seeing this change in the industry, and I think it can be a good thing to the extent that it leads to greater transparency. But like any statistics, law firm analytics need to be used with caution. They have the potential to misrepresent, and it's very easy to misinterpret them. And nobody wants that. Attorneys don't want that and clients don't want that. So today what I'm hoping to do is to provide you guys with some guidelines and tips for using law firm analytics in an actually meaningful way. So to that end, I'm going to cover two things. One, I'm going to cover two overarching principles for evaluating outside counsel, just kind of things to keep in mind anytime you see any kind of metrics on U.S. patent attorneys. And then I'll give you 5 specific examples of metrics that I know that U.S. corporations are using to evaluate their outside counsel right now. All right, so starting with the principles. And again, these are really just things to keep in mind. So one is always consider effectiveness and efficiency. Don't ever look at one in isolation. And 2 is keep in mind the massive examiner variability that exists in the U.S. Patent Office, because that can impact what you're seeing in terms of the performance of your U.S. counsel. All right, so efficiency and effectiveness. You have to consider both, because a good patent attorney isn't just going to be fast at getting patents, they're also going to be good at getting patents, and vice versa. It's not okay just to be good at getting patents or to be getting a lot of patents. You also have to consider at what cost you're getting those patents. So effectiveness, are you actually getting a lot of patents? How good are you at getting those patents? And then efficiency is, of course, how fast are you at getting patents? What's the cost of those patents? And I break it down into these 2 broad categories, really because these are the types of things that it's possible to measure objectively. So for example, with efficiency, we can easily objectively measure things like time to allowance, the number of rejections it took, the number of RCEs that it took. And in terms of effectiveness, it's easy to measure things like allowance rate, how successful attorneys are when they go to appeal, how many patents total have they ever achieved in their career. So that's why I kind of break it down into these 2 bubbles. There's obviously a third component here, which is the actual quality of the patent that you're getting. And I'll touch on that a little bit later in the presentation, but that's a much more subjective measurement, and there's not really any low-hanging fruit to be able to reach at that. And frankly, I'm not even sure that the technology is there to assess that yet. So these are the things that are easy to measure objectively, and so these are the things that I'm going to focus on today. So this is the framework that we have in our system for evaluating attorneys, and as you saw if you attended the last webinar, for evaluating corporations. And it's based on this notion that everything is either going to be measuring effectiveness or efficiency. So on the y-axis, you have some measure of effectiveness. How good is a particular law firm or corporation at getting patents? And in this case, I've selected allowance rate. And then the x-axis is just the measure of efficiency, how fast. And so in this case, we've chosen months. And you'll notice, by the way, that the numbers are in reverse order here. And the reason for that is that we always want to keep this framework where the upper right-hand corner is where you want to be. So the upper right-hand corner is where you are if you're being both effective and efficient. And obviously, you're more efficient if your time to allowance is shorter. So that's why this axis is reversed. The bottom left-hand corner, and the reason it's shaded red, this is where you don't want to be. This means that you're ineffective and inefficient. And the quadrants are defined based on average for any particular technology space. So for this example graph, for the technology space, on average, people are getting patents at around 27, 28 months, and the average allowance rate is right around 86, right? So anything above that would be better, anything below that would be worse. In particular, I want to draw your attention to law firm A, because this is an issue that I see a lot. And it's not an issue for everybody. Some people aren't actually dealing with budget constraints. And in some situations, you want to get a patent no matter what the cost is. But for the most part, this is one of the major issues that I see is counsel and corporations also that are effective but inefficient. So they're really good at getting patents, but at what cost? So they're throwing a ton of money at the U.S. Patent Office. And yeah, they are getting a lot of patents, but they're paying an excessive amount of money for them. And what you're not seeing here also is all the patents that that they may be paying for that they maybe didn't end up getting. So So this is just something to watch out for, because it's something that I see a lot. Obviously, you don't want to be anywhere but the green zone, but this is probably one of the most common things that I see is people just pushing to get patents no matter what. And this is, by the way, I see this from the law firm side and from the corporate side. A lot of the times it's the client that's pushing for this, and not necessarily the law firm. But whatever the case, obviously this is not a situation that most people want, because they don't want to have to be spending a ton of money for the patents that they're getting. They might even be willing to sacrifice a few patents if it meant that they could spend less. So that brings me to another important point here, which is that many of these metrics are not entirely within the law firm's control, right? So one piece of feedback that I often receive from law firms is, well, it was the client that was pushing me to keep filing responses. You know, essentially the client was pushing me to be inefficient. We also know that the choice to abandon, which is typically considered a bad thing, is often not within the law firm's control. It's the company decided to make a different business decision. And so that's why I think it's important to view both of these, to view everything in here as a whole, as painting a picture or telling a story. The statistics are one important piece of the story, but they're obviously not everything. And it also brings me to my next important point, which is that you need to make sure to isolate these comparisons or evaluations to a single technology area or to a single client, because there can be a lot of variability from client to client or from technology area to technology area. But the greatest variation at the U.S. Patent Office, as we know, and as we covered in great detail in the last webinar, comes from examiner variability. So we know that some patent examiners at the Patent Office tend to work more effectively, more efficiently than others, and that's obviously going to have an impact on the corporations and the law firms that work with them. So just to give you an example, here's an example application filed in 2016, granted within 3 years, with only 2 rejections and 1 RCE in between there. So if this were an application in front of, say, examiner A, I would actually consider this to be a bad result. So this hypothetical examiner A, they have an 80% allowance rate, and on average, they allow patents within 1.5 office actions. So if you're taking 3 office actions and RCE to get this patent allowed, I would actually say that's not really a great result. That was not really efficient. But conversely, if you ended up in front of examiner B has a 20% allowance rate, on average takes 3.2 office actions, I'd say this is actually a pretty good result. And so this is just an example of why it's important to be considering who the examiner is for any individual application before you make a judgment about the law firm. So I won't go into a ton of detail here because I know we focused on this a lot in the last webinar, but I do think that it's important that you know why it matters so much that we account for examiner variability when we measure law firms. And it's one major reason is the variability is more extreme than you might imagine. So this slide shows the results of a study that was done by Professor Shine Tu at the University of West Virginia Law back in 2012, although it's equally true today. So what he found back then, when he studied examiner efficiencies and who's really granting patents, what he found is that a very small sliver of the patent examination corps, only 10%, is responsible for almost half of the patents coming out of the office every year. So these are patent granting machines. These guys are granting over 50 patents a year, sometimes almost 100 patents per year. And that's only 10% of the patent examination corps of about 8,000 examiners is pushing out half the patents that come out of the office. Well, conversely, another 20%, a slightly larger sliver, is responsible for less than 1% of the patents that come out of the office every year. These guys are incredibly inefficient, hardly granting anything, maybe less than 5 patents per year. And then, of course, there's everything in between. So what we see is that there's some pretty extreme behavioral differences at the patent office. And if you don't account for those, it could make it seem like your law firm's actually doing pretty badly when in fact they're doing pretty well, or vice versa. They actually look like your law firm's doing really well when maybe they just got lucky and ended up with one of these 10% of examiners. And the other thing is, these examiners, difficult, easy, and hard, can be found in every technology area at the patent office. So in our PatentAdvisor system, we describe examiners basically based on color, right? So that small 10% that grants almost half the patents, we categorize those in our system as green. And that 20% that's granting very few patents, we categorize them in our system as red. And it's all based on this metric that we call ETA, which stands for examiner time allocation. And what ETA is it's the total number of office actions divided by the total number of allowances across the examiner's portfolio. So when the examiner comes into work every day, they pull up application number 1 and they write a rejection. They pull up application number 2 and then they write a rejection. Then they pull up application number 3 and they grant an allowance. That examiner would have an ETA of 2 rejections to 1 allowance. So if the examiner's ETA is below 2.5, we consider them to be green. And if their ETA is above 6, we consider them to be red. And this can go all the way up to 99, by the way. So this can get really extreme. But the point here is these examiners exist in every single technology space at the Patent Office. There's actually 8 technology centers at the Patent Office, but I picked these 4 for the sake of illustration because this includes the easiest and hardest technology areas at the Patent Office, right? So 2800 is the easiest. And as you can see, it definitely has a higher percentage of these green examiners, but there's still some red ones. 1600, 2100, 3600, these are the toughest ones at the Patent Office. And as you can see, they definitely have more red, but they've also got their fair share of green and yellow. So really, anytime you're filing at the Patent Office, you're playing a little bit of a lottery, and there's a chance that you can end up with any different type of examiner. So what do? How can you account for this variability? Well, one thing that you can do is to limit your comparison as much as possible. So you could limit your comparison to a particular technology space or to a particular corporation. And I'll just give you an example to show you how important this can be. So this is a hypothetical example of law firm performance for a particular company in technology area 3600. Remember, there are 8 technology centers at the U.S. Patent Office. So this is a pretty broad area of technology. All right, and you can see most of the law firms that I picked for this hypothetical analysis are actually in the green zone. They're doing better than average in terms of both efficiency and effectiveness. But now let me limit this comparison a little bit, right? So now I'm not going to just look at 3600 overall. I'm going to narrow in on a portion of 3600 that deals with business method software patents, which, if you don't already know, getting a business method software patent at the USPTO is always challenging. It's been particularly challenging since 2014, but it's never been a walk in the park. So let's narrow in on that really difficult technology space. The landscape completely changes. So Denson's moved from actually being over almost in the red zone to being in the green zone. Most of these law firms that were in the green zone suddenly moved over to the red zone. This is why it's so important to control for technology as much as you can. Now, obviously, when you start getting really, really narrow, maybe you limit to only a single art unit that has about 50 examiners. Well, obviously, you're going to start to run into small data problems. But so typically, I tend to stay in the technology center group area because it tends to have enough data that you can run a meaningful comparison, but it's also limited in terms of technology. But hopefully you see why this is so important. Now, in PatentAdvisor in particular, when it comes to efficiency, we have our own proprietary metric that actually normalizes for examiner variability. So when it comes to efficiency, if you're measuring with PatentAdvisor, we can help you out there. But otherwise, the best thing you can do is just to limit it as much as possible. There are different types of examiners, red, green, and yellow, in every technology space. So the more that you can limit it, the better. But you're never going to completely wipe out the variability unless you expressly normalize for examiner variability. All right, so those are the 2 overarching principles that I wanted to talk about. Make sure that you're considering both effectiveness and efficiency. Don't sacrifice one for the other. And also always keep in mind that there's this examiner variability happening at the U.S. Patent Office, and that could be impacting what you're seeing. So try to eliminate that variability as much as you can by only looking at a narrower technology space and or by expressly normalizing for examiner variability using one of the PatentAdvisor proprietary metrics. All right, so the next thing I want to talk about are 5 metrics for evaluating U.S. counsel. Those are allowance rate, good use of USPTO strategy options, technology area assignments, avoidance of unnecessary costs, and the PatentAdvisor efficiency score. And these metrics, some of them relate to both effectiveness and efficiency. Some relate to one or the other. But the important thing is that we're looking at metrics that relate to both of these things. So it's important not to look at any of these in isolation. And these aren't just things that I came up with. This comes from working with customers in a variety of technology spaces with varying portfolio size, everything from 10 filings per year to 10,000 filings per year. And after talking to these customers for years and years, this is what I'm seeing that they're looking at. And the PatentAdvisor efficiency score was developed after years of talking to these companies, trying to understand what they care about in terms of efficiency and obviously normalizing for examiner difficulty. All right, so the very first one that I'll talk about is allowance rate. This is going to be by far the most common metric that you see when it comes to law firms. And it's probably my least favorite. I would definitely say use this metric with caution. And there's a lot of reasons for that. So what is allowance rate? Typically, I'd say the vast majority of people define it, and we define it in PatentAdvisor as patents divided by patented applications over abandonments. So you can almost think of it as what's your chance of getting a patent with this law firm or for this corporation. I also see some people defining allowance rate as the percentage of patents that were obtained before the first RCE divided by total patents plus abandonments. So obviously that's going to be a much lower score. So just be sure that you know which one you're looking at. But either way, be incredibly cautious with this metric, particularly when you're using it to evaluate a law firm. And here are my reasons. First of all, it basically penalizes you for abandonments, which a lot of times are not within the law firm's control. And I would say most of the time it's not within the law firm's control, right? Sometimes it's because the client says, I just don't want to continue this case because I'm taking the business in a different direction. And sometimes it's because they were working with an examiner who was just impossibly difficult, and they had to give up, or the client eventually wanted to stop paying. So that's one issue with it. 2, it's a lagging indicator. It takes a while to catch up. The U.S. patent life cycle is long, 3 to 5 years. So if you're working with a law firm that's new, maybe a partner just broke off on his or her own, and they don't really have many metrics yet. It's going to take a while for them to build up their allowance rate, and for a while it's going to swing back and forth a lot until they have really an established caseload. So that's another problem. It doesn't account in any way for efficiency, which I'm sure you're aware of at this point. But the point is, I feel like a lot of people tend to look at this in isolation, and that's not really fair, because it may be that a particular law firm or corporation is getting a ton of patents, but they're spending a lot of money to do so. And finally, same problem as it's a lagging indicator. You need a large number of patents to really make the score be meaningful. Otherwise, if you've only, say, you had bad luck in your first portfolio, just didn't work out for you very well, you might have a really low allowance rate, and that could be misleading. So this is something that everybody's going to look at. I get that. I get that it's important. I'm just saying, use this metric with caution, particularly if you're dealing with a newer law firm who might not have built up a lot whose portfolio is not very large yet. The second most common measure of effectiveness, and this is really a bunch of different measurements that I've lumped into one category. This is the law firm using the strategy options that the USPTO provides in an effective and efficient manner. So right, there's kind of 2 parts to being a patent attorney. There's the substantive part. Are you good at making good arguments? Do you have the right arguments in your toolbox? Can you talk to the examiner and convince them? Are you a good negotiator, right? But then there's also the procedural strategy component. The USPTO offers a lot of different strategy options to help you get your patents efficiently. Are you utilizing those, and are you utilizing them well? So for example, appeal, right? You can always go over the examiner's head if things aren't going well. You can choose whether or not you want to have an interview. There's various pilot programs that the Patent Office provides over time. There's after final pilot, which is the most common. Basically, it's the USPTO's acknowledgement that it's really hard to actually come to an agreement after 2 rounds of negotiation, and sometimes you just need a little bit more. And then there's track 1, which is the ability to pay a fee. I think it's about $4,000 or $5,000. And then the Patent Office guarantees that you'll get some kind of resolution, get to the first RCE basically within a year. And they do. They stick to that promise. So there's all these various strategy options. So is the law firm actually using them to their benefit? And when you consider this, there's 2 important things that you want to look at. You want to look at the immediate outcome and the ultimate outcome. They're both important. For some programs, I'd say that one is more important than the other, and I'll speak to that specifically with respect to each of these strategy options. But basically what I mean when I say immediate outcome is, okay, you just filed the notice of appeal. What happened immediately after? Did you get an allowance? Did you then file the appeal brief? The example on the screen, when you asked for an interview or when you had an interview, what happened immediately after the interview? It's really telling if, for example, there's an abandonment right after the interview. I mean, how bad was that? That must have been a bad phone call. If you got off the phone with the examiner and immediately decided, yep, gonna throw in the towel with this case. And also by the same token, if you get off the phone with the examiner and the examiner immediately allows it, that says something too. So that's what I mean by immediate outcome. And the ultimate outcome is, did it ultimately get allowed? So for example, for interviews, what percentage, so for cases that were interviewed, what's the allowance rate? And for applications that were not interviewed, what's the allowance rate? Now, for interview and after final, and also for appeal, I would say your focus should definitely be on the immediate outcome and not so much on the final outcome. In fact, I would even say be cautious about looking at just the final outcome because it can be biased. So for example, if you looked at the percentage of applications that had an interview that were allowed versus the percentage of applications with an interview that were not allowed, the percentage of applications that were allowed with an interview, it's going to be higher every single time. And the main reason for that is that people don't interview a case unless it matters to them, right? Well, I know there are some attorneys and some corporations whose practice it is to interview every case, and I think that's awesome. But it's definitely not everyone's practice. And so often when you see an interview, it's because that case was already important to that applicant. And so, yeah, cases with interviews are always going to have a higher allowance rate. It doesn't tell you a ton. What tells you a lot more is what happened right after the interview. Right after you got off the phone with the examiner, what was the result? Was it allowance? Was it abandonment? Did you get another office action? Did you have to file an RCE? That to me really tells you whether the interview itself was successful or not. So I would say for interviews, definitely focus on the immediate outcome. Same with after final pilot. So this program, what it allows you to do is after you receive a final office action, it gives you one extra bite at the apple and it allows you to make some pretty significant claim amendments and have an interview with the examiner, which normally wouldn't be allowed after a final rejection. And so after you file a request for this program, there's 3 basic outcomes. Either you're going to get an allowance, you're going to get an advisory action saying, yeah, no, you're going to have to file an RCE and do another whole round of negotiation. Or occasionally examiners misuse this program and something else happens. But the 2 things that should happen, you should either get an allowance or you should get an advisory action. Those things tell you whether the request itself was successful. Obviously, it's helpful to know down the line, of these cases that got an advisory action, were they eventually allowed or were they eventually abandoned? That can be helpful too. But I think it's more important to understand for after final pilot what happened immediately, because that tells you whether the program itself was a success for you or not. Now, with appeal statistics, there's a lot of other issues to consider as well. So definitely you want to look at the immediate outcomes. Right after you filed the notice of appeal, was there an allowance? Was there an abandonment? right after you filed the appeal brief, was there an allowance or was prosecution reopened? And perhaps most importantly, which applications made it all the way to the board and what happened with those? You know, if you have a law firm that's taking applications all the way to the board a bunch of the time and those cases get abandoned, that's obviously not good, because this is an expensive strategy option, an important and effective one, but also a very expensive one. So here, obviously, the immediate outcome is also very important. But one additional thing I want to highlight here that's specific to appeals are applications that get pushed back into prosecution after you file an appeal. So what I mean by that is you tried to go to the appeal process. You're trying to go over the examiner's head. So you file an appeal brief, you file a notice of appeal, you file a brief, maybe you get an examiner's response, and then the examiner acknowledges that you're right, at least about something, and so says, okay, I'm going to reopen prosecution and we'll deal with this ourselves. That is going to happen some portion of the time, every time. You'll always see some percentage of cases that get a final or non-final office action in the middle of an appeal. And it's because the examiner realized, okay, you have a point. Let's talk about this amongst ourselves. Let's not involve the board. But when you see this happening a lot, that can be a major red flag, particularly if you see those cases going back through having multiple appeal cycles. You know, you obviously don't want to have to go through the appeal cycle more than once. You don't want to get pushed out of appeal and then 2 years later having to file another appeal brief. So that's just something to watch for. Also, if you are in that situation and you do get pushed out of appeal and then have to go back in 2 years later, make sure that you're not paying double for that. That's another red flag that I've noticed that you see a lot. If you are pushed back into prosecution and then choose to appeal later, you don't have to pay double fees. So that's another thing just to notice in terms of appeal statistics. Then finally, the last strategy option that I'll talk about is track one. This is basically putting your application on the fast track by paying a fee. And it's a pretty hefty fee. And so obviously you probably don't want to be using it every single time. But I do think it's important for people to be using this sometimes, because not only does it get you a patent a lot faster, but the allowance rate with this program is much higher. So this is just an example. If you look at Technology Center 1600, which is kind of biotechnology, pharma, vaccines, if you look at the allowance rate overall, it's pretty bad. It's basically a coin toss. Average number of office actions to patent issuance isn't too high, and the average time to patent is 2 years, or well, almost 3 years. But for those applicants that file track one, look how the allowance rate jumps up to almost 80%. The time to allowance and the office actions to allowance, yeah, those are reduced, but the allowance rate jumps way up. Now, part of this just has to do with the fact that it's kind of like the interview statistic thing. You know, people are only filing track one on applications that are really important, that they really care about. So of course the allowance rate is going to be higher. But I also think there's more here. So the USPTO doesn't tend to give track one applications to new examiners because they know they can't get it done in time, right? The USPTO's promise with track one is, we'll get you to some kind of resolution, even if it's just your first RCE within a year. And like I said, they're really good at sticking to that. It's going to be hard for a new examiner to do that, right? New examiners, they're new at their job. There's a lot of administrative hurdles to them actually allowing a case. So you're more likely to end up with an experienced examiner when you file track one. And experienced examiners tend to be green examiners in our system. Remember, those are the examiners that are efficient, that grant a lot of patents. So all this to say, track one is a very valuable program when you need it. It's not only going to get you patents faster, but it's more likely to get you a patent. So make sure that your U.S. counsel is using this program selectively for cases that actually matter to you, because it does get really, really good results. All right, so the next thing that I see a lot of corporations looking at, and this is a newer trend. This isn't something that people have been doing for a long time, but it is a very up and coming trend in the industry, and that is avoiding difficult technology spaces. So at the beginning of the webinar, we talked about how some technology spaces simply are more difficult than others. True, there's red, green, and yellow examiners in every technology space, but some tech spaces have a greater percentage of red examiners, and some have a greater percentage of yellow or green examiners. And the thing is, we know this going in, right? We have tools that can predict the technology space that your application is going to go to. And attorneys who've been practicing a lot, they generally know what art units their applications are going to be assigned to because they've been working in these spaces for a long time. So they mostly know where they're going to be going, especially if they're experienced. And they also know that some technology spaces are harder than others. The most extreme example of this is 3620, 3680, and 3690. These are the most difficult technology center groups at the U.S. Patent Office because these cover business method software patents, which in the U.S. Supreme Court case, Alice versus CLS Bank, made it almost impossible to get a patent on these cases for a while. So to the extent that you can avoid getting placed in these technology spaces, you should be doing that. And it is possible to do that. Now, it's not possible to do it every time. Sometimes the technology in your invention just is the technology in your invention, and it is going to go to a particular technology space. Sometimes it's completely unavoidable. But more often than you would think, it's actually possible to change that by recharacterizing the technology in your invention and specifically in your claims before you file. I work with patent attorneys who have completely avoided, who work in software, who write patents on business methods, who have completely avoided these groups for years now by learning how to reframe the technology. And you know, it's not, I've talked to a lot of people that do this, and their immediate reaction is, well, this is forum shopping. You know, you can't, how am I going to trick the USPTO into getting me into a different technology space? You're not tricking the USPTO. It's nothing like that. Literally, the USPTO is divided into technology sectors for a reason. It's so that applications go to an examiner who understands the technology and is in a position to review it. So what I'm talking about here is having the lawyer actually look at the invention and try and figure out if there's more than one technology area where the invention could go. And if so, to guide the invention, to guide the application towards the technology space that has fewer red examiners, and it's going to be more favorable to the applicant. So when you're reviewing your law firms, it's one thing to look, it's something you should be looking at. Is your law firm often ending up in difficult technology spaces? So this example here on the slide, these are the example art units for a particular law firm. And you can see they're kind of all across the board, although most of their applications are ending up in pretty good technology spaces that have pretty high allowance rates. So that's just something to look at, particularly if you're in the software art and there really are these areas that you want to be able to try and see how many applications your law firm is getting in these difficult technology areas versus other law firms in the same space. All right, so now we come to the PatentAdvisor efficiency score. So after years of working with companies evaluating their outside counsel, we realized there was a need to create a metric that was actually normalized for examiner variability, right? You know, we do recommend limiting your comparisons to a technology space, limiting a law firm evaluation to a particular client, but that only gets you so far because there are red, green, and yellow examiners in every technology space and for every client. So for efficiency, what we did was we actually created a metric that's normalized for examiner difficulty. It takes that completely out of the equation. And the way that we do that is that we actually went into our system and we gave every single application in our system a score, a positive score if it was good, a negative score if it was bad, based on par for the examiner that the application was assigned to. So in the example here, these are two applications that were in front of a yellow examiner. So this is an average middle of the road examiner. For this examiner, we would expect some kind of resolution for a patented case, say after 2 office actions and 1 RCE. And we would expect some kind of resolution on an abandoned case, say after 3 office actions and 1 RCE, right? We assume abandoned applications take a little bit longer because it takes longer for you to decide that you want to throw in the towel. We understand that, right? So this first case is an obvious disaster. 14 office actions, giant appeal, tons of RCEs. Yeah, it was immediately allowed, but not very efficiently. So we're going to give this case a negative score, probably a very negative score. Then this other case was allowed after a single office action. That's fantastic. We're going to give that case a positive score. That's a win. So then for any particular law firm or corporation, what we do is we average all of the scores for their applications into one overall score, and that is their efficiency score. It's on a scale of 0 to 100, where 100 is good, 0 is bad, and 50 is about average. Oops, sorry. But the benefit here is that it takes this variable out of the equation. Right? We're more lenient if you end up with a red examiner. We're more stringent if you end up with a green examiner. It also doesn't matter how many applications you prosecuted. You know, we can give you a score for 2 applications or for 100. It doesn't really matter. And we're not directly penalizing the law firm for abandonments, which I think is huge. Because as I mentioned earlier, I don't really think abandonments are the fault of the applicant, of the law firm. And so we don't want to penalize for that. So just to give you an idea of how important it is to consider examiner variability and to use the PatentAdvisor efficiency score. Here's another sample analysis of some law firms in a particular technology space. So I think I picked Art Unit 1663, which is the biotech space. Denson's is obviously the big player here, and then I picked a bunch of other law firms for the sake of comparison. So right now I'm looking at the efficiency metric of time to allowance, just how long did it take them to actually get an allowance. And you can see Denson's is by far winning here. They're doing the best. They're getting out allowances in an average of 8 months from the time of the first office action. But now let's normalize this. Let's change the scale to the PatentAdvisor efficiency score and see what happens. There was a bunch of movement. So Denson's is still the leader, but Drinker Biddle is starting to come out here a little bit on top. You can see a bunch of firms moved over. So this is a completely different landscape than what we were just looking at. And it's because we were, in the original one, we're not considering who the examiner is. You know, maybe Drinker Biddle just had some really bad luck and ended up with some really difficult examiners. Because when we normalize for examiner difficulty, they actually end up in the green zone for efficiency. So to the extent you can, we recommend you measuring efficiency with this score as opposed to, you know, one of the other metrics, time to allowance, number of office actions to allowance. But to the extent you do have to rely on those other metrics, at least make sure that you're limiting to a pretty narrow technology space. Now, we also break down the efficiency score by examiner type. And in particular, I want to draw your attention to the red score, right? So we give every law firm an overall score, which is just their average efficiency score for all of their applications. And remember, it's on a scale of 0 to 100. 0 is bad, 100 is good, and 50 is about average. But we also break it down. So we also average just the applications that were assigned to red examiners, just the applications that were assigned to yellow, and just the applications that were assigned to green. And the reason we do this is that we want you to see how law firms are performing with the difficult examiners, because to me, that's the true measure of merit, right? It's not that hard to get a good result with an easy examiner. These are patent granting machines. They want to allow your application. It's what they do. They're allowing 50 to 100 per year. And so what you'll typically see is that most law firms have a score right around 50 for green examiners, because it's hard to do a lot better than average for a green examiner. It's also rare to do a lot worse. You're typically just going to be right around par for the green examiner. For yellow, you'll start to see some variability, but where you always see the greatest variability is with red examiners, because it's really difficult to do better than average with these guys. But if you can, that to me says that you are an excellent attorney. So right in this example here, law firms 4 and 5, their overall scores in the 60s, which is good, you know, obviously better than average. But when you look at their red score, you see that's where they're really excelling. these guys are doing good with the difficult examiners. And so I think that's something to pay attention to. All right. So the last thing I'll talk about in terms of, and this is also in terms of measuring efficiency, although I guess it also goes somewhat towards effectiveness, is avoiding unnecessary fees. So getting a patent is expensive, obviously. It already costs a lot of money. You don't want to have to pay extra money because the law firm made some kind of administrative error, right? And there's a ton of these that we could look at. These are just the top examples, right? When you file a response late, that incurs an extension fee. If you forget to file your information disclosure statement before the first office action, that's going to result in an IDS fee. If you have to file an IDS after an allowance, you're going to have to pay an RCE fee. And then this is the real biggie, avoidable 112 errors. The 112 rejections, those are often based on, basically failure to follow USPTO rules about how to write a claim. Many of these are entirely avoidable. And so we measure how many of these rejections you're getting from any particular law firm, so you can understand whether they're really getting too many of these and they should be avoiding some. Now, not all 112 errors are avoidable, particularly in the biotech space. So again, as I've said all along, it's really important to look at this stuff in the context of the technology area that you're in. And to the extent you're running a comparison, make sure you limit to a technology area, because otherwise your biotech law firms are going to look really, really bad. But assuming you are looking at a pretty limited technology space and you see one law firm getting more 112 errors than another, that could be an indication that their drafting is sloppier than it should be. And with these things, one thing that's important to try to set monitors to identify these issues early. We can set monitors on any of these things to alert you to the fact that any of them happened the minute that they happened, because the last thing that you want is 5 years down the line to be looking at a law firm and noticing that they continue to make one of these mistakes over and over and over, and it's been costing you thousands of dollars over the years. We can alert you to the first time this type of thing happens, so you can circle back with your law firm and let them know that it happened. All right. So at this point, I actually want to take a poll, because there's one other major metric that I see corporations looking at, and there's a lot of mixed feelings about it. So I want to know what the people on the line think about this. And specifically, that's claim metrics. So when I talk about objective claim metrics, specifically what I'm talking about is how many words per claim, how many claims altogether, what are the changes in the number of words per claim over time. I want to know if this is something that you guys are looking at. If you're a law firm, is it something that you track for yourselves? And if you're a corporation, is it something that you're tracking for your outside counsel? So yeah, yes, no, sometimes, or you just don't know. Well, let me see. We'll wait for a couple minutes for the results to come in. But in the meantime, while I wait for you guys to share whether you look at this or not, I'll let you know kind of what the literature is on this at the moment. And the truth is, the literature on this is divided. People really are out there studying whether claim statistics are something that you should be looking at in terms of measuring outside counsel. But there is no consensus whatsoever. I have seen, and many of the corporations we work with are on polar opposite sides of the table here. Some of them are absolutely adamant, that claim statistics are not something you should be looking at because they don't mean anything. And some of them are adamant that it's something that you should. And then I've seen everything in between, and the literature is the same way. So a couple of the most interesting studies I found, probably the most interesting study I found, this woman studied claim lengths over the last 50 years. She looked at a random sampling of patents across all technology spaces for 50 years to see if the number of words per claim has changed over 50 years. And of course, when I read the study design, I'm like, of course it's going to change. Of course it has. 50 years? I mean, come on, technology has changed. Patent law has changed. Different technologies are different. Guess what? It hasn't. It hasn't changed at all. And her theory is, well, it hasn't changed because patent attorneys are just writing claims the way they think that examiners want to see them. They think examiners want a particular length of claim, and so they're writing them that way. That's her hypothesis. But regardless of what's causing this, to me, it's a pretty strong indicator that claim length doesn't matter a whole lot if it hasn't changed. If it's not reflecting technology changes or changes in the law, does it really signify anything? I don't know. But then on the flip side, there's studies that indicate that maybe it does matter. There was a recent study by Kuhn and Thompson suggesting that at least the length of the first claim is actually proportional to the scope of the patent, right? So a claim with very, very few words is going to be broad, and a claim with too many words is likely to be narrow. And then I saw another study on IP Watchdog that showed, and this is talking about claim lengths during prosecution, but what Eric Sutton found is that extremely short claims, less than 300 characters, are rarely issued. So I'm not actually seeing the results of the poll. Nabu, maybe you can show them to me. So, because I'm very interested to see if people are actually relying on claim statistics or not. Because in the industry, I've seen both. But all right, so maybe we'll be able to look at that later. All right, so at this time, I'd like to pause and see if there are any questions from the audience that I can address. Nabu, I'm not seeing anything. If you have anything, maybe you can show me. All right.
Yeah, hi, Megan. So there is one question.
Oh, hey.
Yeah, sorry about that. There's one question from our audience. Just a second.
Mm-hmm.
So it is from Thomas Breidenbach, and he asks, we have an outside counsel who has not recording assignments, but still naming our corporation as sole applicant on PCT applications. Can you automatically check for this discrepancy and issue a report on it?
Yeah, absolutely. We could check for something like that. So we could tell you, we know the names of all the assignees on any U.S. application, and so we could absolutely check it for any new application that was filed with that particular assignee. That is something we could do. That's a good question.
Okay.
Yeah, then it's an interesting point too, because every corporation has something like that, right? Something specific to them that they're noticing. And so what we have and what we use for these avoiding these unnecessary fees, we have these things called prosecution pattern monitors. And what they do is for any particular patent portfolio, they can alert you to any pattern of events that happens in the file history. So if there is something in pair that we can measure, whether it's a document or a piece of information in the XML, and we can measure it, we can set up a monitor around it and alert you to when that data happens or when that data changes. And I see now, by the way, the results of the poll as to whether or not you do look at objective claim metrics. 23% said yes, 15% said no, and about 40%, the majority, said sometimes, which is interesting and I think consistent with what I'm seeing in the industry. Because there's so much ambiguity around these statistics, I think people don't necessarily know how to use them. So they just use them sometimes. I think that makes sense. Okay. So now that you understand, hopefully, a little bit more about how to evaluate your U.S. counsel at a high level. I'm sorry. So actually, I just want to sum up right now, now that we've reached the end of our webinar. So today we've talked about two principles, overarching principles for evaluating U.S. counsel, right? Unless you're in this unique position of not having any budget concerns, you always want to be considering both efficiency and effectiveness. And remember that examiner variability is the main source of outcome variability at the Patent Office. So try to account for that as much as you can, either by limiting to a technology space, limiting your evaluation to your own portfolio with that law firm, or by using the efficiency metric where we've done that for you. And then these are the 5 metrics that we see US corporations taking into account the most. So all of these metrics that we discussed today are available in PatentAdvisor. You can generate an analysis on any of these for any law firm that practices in the US, for any tech area, and for any client. So if you're interested, please reach out to us. We work in partnership with the Patent Site team, so you can reach out to them as well. Thank you again for listening today. If you guys have any more questions, please feel free to reach out to us. You can even send me an email individually, and we will get back to you as soon as we can. Thank you for your time, everyone.